What I'm trying to do in the book, as a sort of framework matter, is draw a distinction between a vision of the First Amendment that I call provincial, that sees the First Amendment as domestically applicable and important primarily, if not exclusively, to U.S. citizens who are speaking and associating within our borders. And I think the First Amendment has another aspect or perspective that ought to be talked about as well, in particular in the 21st century, and that is its more cosmopolitan orientation. The extent to which it should, in my view, protect citizens' ability to speak and to travel and to gather information across borders. I think we have a view in the United States that we censor and suppress less speech than other parts of the world. And I don't think that story is entirely accurate. If you think about confidentiality rules and state secrets and things of that nature, we have a pretty robust bureaucracy of censorship still in the United States. It's not nearly what it was in the World War I period and World War II, and certainly through the Cold War. But the mistake is to think it's disappeared. That we have a fully liberalized, fully formed free speech culture in which our government doesn't seek to punish, doesn't seek to suppress, doesn't seek to inhibit the transmission of information. It does all of those things still. It does not do them as much as, of course, China and authoritarian regimes, but it does them more than I think is commonly acknowledged. I talk about Julian Assange in the book and about the changes to institutionalized press and a possible U.S. prosecution of him, a foreign national, in a U.S. court, which is still a possibility. Now we have to think about Snowden, who communicated all these confidential documents and the extent to which he's going to be pursued. It's been another big issue recently. Material support for terrorism is a crime under U.S. law. And in a case called Holder versus Humanitarian Law Project, the Supreme Court held that the U.S. government could criminalize acts such as trying to help a foreign organization that the U.S. designated as a terrorist organization in filing a brief in the United States court, or in teaching that organization how to peacefully resolve its disputes at the United Nations. And I level a lot of criticism at the Holder versus Humanitarian Law Project decision because I think it exemplifies a sort of exceptional treatment for speech or association that's not confined to our borders. The notion that there are scary ideas and that the government should have the power in some way to suppress them or to regulate them in a very strict way is certainly not new. The context in which we speak and communicate now is quite new. I do acknowledge in the book that the government has serious national security and foreign affairs powers and concerns in many of these contexts. I think the balance has been struck, though, in a way that creates a sort of exception to freedom of speech. Whenever the government can say an association or a communication crosses borders, it can take the position under current law, it seems, that it has the ability to suppress or criminalize. And I think that needs to be changed.